Hello, I'm Colin Moriarty, an attorney with Underhill Law, and welcome back to the Underhill Law Workshop Series. In today's seminar, we're going to cover something that's a very, very basic legal concept. If you happen to be an attorney, you'll remember it from taking your bar review classes, if not before that. But for other people who are just doing business in Colorado, these are still important things for you to know. And you might be able to find these other places, but we want to make sure you're familiar with the points of law that relate to it. I'm talking about contracts, the way in which private people put their lives together. So first, what are the elements of a contract? Whether you know them or not, you have two kinds of common law or court-made relationships with every other human being in the world. Contract and tort. Statutory too, but we're only talking about common law here today. Tort is at a very fundamental level the rules that define the duties and relationships between people who have not sat down and decided for themselves what kind of relationship they want to have. Contract law applies, usually, when people have done that. They've sat down and made an arrangement about the kind of relationship they want. A contract consists of four major parts: an offer, an acceptance, consideration, and mutual assent. So let's go through those. An offer, what is that? That's when someone offers to do something or give you something. For example, providing your contract form. A clear offer will say, I will do this if you will do that. I will pay you this in exchange for that. If you have a simple invoice or purchase agreement or even purchase order that simply lists off what you're selling and what the price is, providing that to somebody can be an offer. After that, there must be acceptance. Acceptance means words or conduct that, objectively viewed, show that the person getting the offer wanted to accept it. This can take a lot of different forms. The most commonly understood way of people accepting your offer is going to be their signature or their mark on the contract. In the olden days, before everybody could reliably write, sometimes an X would suffice. The important point is that the person getting the offer shows they accept it by signing or marking the document. But that's not necessarily required. You can also have affirmative language, such as, I agree, to make a contract. If you send an offer to somebody by email and they respond by email saying that they agree to it but don't actually sign the document you sent them as an attachment, that may still be enough. You can also have affirmative language that's verbal. Someone can simply tell you they agree to it. That can form a contract too. Although, as we'll talk about, that makes proving the contract a little more tricky. You can also show somebody accepted an offer through their actions. So, for example, if you are offered money to photograph a wedding and then you show up and do it, even if you didn't sign the contract or respond to the email, your actions in responding to that offer may show that you accepted it. So once you have an offer and acceptance, those are the first two elements of a contract. Traditionally, though, contracts also require a third thing, which is called consideration. Consideration is what separates contracts from gifts or gratuitous things, where you give someone something without expecting something in return. Consideration is an exchange of something of value, the X for the Y. You can have consideration in the form of services. I'm going to do something for you. You can have an exchange of promises. You can simply say, you do this and I promise to do that, or we both agree to something. This can be a promise to act, such as showing up and photographing a wedding, or it can be a promise to forbear from acting. I will not compete with your company if you hire me and pay me on these terms. Both of those can be consideration. Now, a contract also needs to have what's called mutual assent. We talked about acceptance, and this is similar, but what it basically means is that both people who are forming the contract have to both agree on what the deal is. There has to be what the law requires and calls a meeting of the minds. Now, this has to be on all the necessary terms. That doesn't necessarily mean that when you form a contract, you have to have reached a total understanding of every little nuance in every term and condition. It means you must have an agreement on the necessary terms. What does that mean? Well, it depends on the type of the contract. But for a lease, for example, a lease would require at least an agreement on what's being rented, what the premises are, what the rent is going to be, what the price is, what the term is, how long is it going to be leased for, and those kind of things. For a sale, you'd probably need to have an agreement on exactly what's being sold and what the price is. Now, context can matter too. So depending upon what kind of deal you're striking, other things may be necessary, such as the date. Is there a performance date that's critical? Is there a shipping date or receipt date that's critical? What about the rates that are being done there? Now, because you have to have mutual assent, there's an area of the law called the Battle of the Forms you may have heard of. The Battle of the Forms refers to a situation where you have two different people making edits or using different versions of the deal and exchanging it with each other. And at the end of the day, if you don't have attorneys on both sides who are mindful and careful, you can end up with a spaghetti soup about what the contract actually is. The Battle of the Forms arises when one person thinks they've agreed to one contract, a second person has agreed to a second contract, and now a court has to decide what, if any, deal was actually struck. This is why it's important to have a good attorney help you with your contracts. Entering into a contract with somebody is easy to do. You can shake hands, you can have a discussion, you can exchange a document, you reach a deal. Now, how are you going to prove it? Because the only thing a contract lets you do as a matter of law is go to court and sue on it if someone breaches it. That's what it's for. That's its primary motivation. The law helps you enforcing your contract. So it's important when you're forming a contract that you always think ahead to how it's going to be proved. You may have noticed that nowhere in the definition of a contract we just went over did I ever say that it had to be in writing. And that's because usually it isn't. It can be verbal. People can and do work on handshake deals all the time. But that doesn't mean it's wise. So let's talk about verbal contracts, written contracts, and how to prove them. If you enter into a verbal contract with somebody, such as, I will sell you this car for this price, how are you going to prove it later if they change their mind? One example is if you have a business sale. This happens a lot in my practice, where somebody has a certain business they want to sell, they talk about a price, and later on somebody disagrees as to what's being bought or sold, or what the price actually was. How are you going to prove what the deal actually was if it's purely verbal? Well, what's going to end up happening is you're going to be in a he said, she said situation. These kind of situations are great from the attorney's perspective because they practically guarantee that there's going to be a disagreement of fact that's going to require a trial to figure out. It's going to be difficult to prove the terms without it. Because verbal dealings between people are so common, though, it's important to think about how you can take those verbal deals and make sure there's something you can prove. Obviously, having them written down is better. But at a minimum, because we all have smartphones, we all have email accounts, we all have the capability to very quickly make a written record of any deal we strike. So sending an email, sending a text message in which the necessary terms that you've agreed to in the deal are written down is a very good idea. It's a good way to show it. After you get off the phone with somebody and you strike a deal, you modify a price, you arrange on a date for service, sending them a quick text message or confirming email saying, per our discussion, we just talked about X and you said you would do Y, would be amazing. What about recording the verbal discussion? Well, unless you're an attorney, which we have special rules for, it's not illegal or necessarily improper to record secretly a conversation that you are part of in Colorado. But I always caution people about that because secret recording can be unethical. That's why it's bad for attorneys. And it certainly looks bad. You, as the person recording, know what you're doing. The other person doesn't. And so the expectation is that you're kind of putting them in a bad light. That said, a recording of the deal that you're striking verbally is pretty good evidence about what the deal is. Now, some kinds of contracts, some very specific kinds, do have to be in writing. These are contracts that fall under what Colorado and other states call the statute of frauds. In Colorado, it applies to these kinds of contracts. Contracts dealing with real estate. If you are looking to buy or sell real estate, potentially secure your loan by real estate, things like that, you may need to have a contract in writing or it'll be thrown out, even if you prove there was a verbal deal. Any contract that cannot by its own terms be fully performed in 1 year has to be written down. So you can't agree to work for somebody for the rest of your life as an indentured servant unless it's in writing. There's other reasons you can't do that too, but that's one of them. Another kind of contract that has to be in writing under the statute of frauds is answering for the debts of another. This is what you'd call personal guarantee, for example. The fourth kind, and this is for the most part, there are exceptions, is sale of goods. If you're selling something to somebody else, especially above a certain dollar amount, it has to be in writing. Now, this isn't an exhaustive list because in addition to the statute of frauds, Colorado also has several other statutes that, depending upon other contexts, do require something in writing. For example, if you're a contractor and you want to have a mechanic's lien against somebody and enforce a construction contract over a certain dollar amount, you may have to have a document in writing as well. So, in a perfect world, any contract that you really want to enforce later should be written down. As we discussed, this is for a couple of reasons. Number one, it's easier to prove what the deal is. If you wrote the deal down, people can read that deal and figure out what you actually intended. The second reason is that it makes proving mutual assent and proving acceptance much better. If you get a signature, you can very easily see that this contract was accepted, which is why businesses do it. You can also track modifications. So for example, if you're going to make a change to the deal and it's written down, you can simply make a modification to the written document, make a new written document, initial changes, and so on, keeping a record. But having it in writing in the first place is only part one. You still have to make sure it's available later on when you need it. So ask yourself, where did the contract get kept? If you use independent contractors and you have them sign yearly seasonal contracts for sales work, do you keep those in an organized way? Are you having a filing cabinet that organizes people by year or by date or by name? Are they posted online somewhere? Is your attorney going to be frustrated when you want to sue somebody by finding that you've lost the contract? This happens more often than you would think. And as an aside here, if your filing system for your business is just your Outlook email box, please stop that. That is a terrible place to store your information, and it may bite you in the butt later on. Another way you can make sure you keep the contract is scanning the signature and making sure you have a digital copy of all your paper files. That can make retrieval easy. I've even seen some people in the modern age who will do a couple of ways to make sure they're getting signatures without killing trees and making it easy for their staff. This can include using a dry erase marker on a piece of plastic over your contract so that the person reads it, the customer signs it, that gets scanned, and then the document is cleaned and used again. I've also seen a lot of people give their sales staff iPads, and therefore they can just simply have the person sign there, and it's automatically saved. The more contracts you sign, the more important it is to be careful about keeping the evidence of what the deal is and that they agreed to it, and all of these things can help. The flip side to this, of having something in writing and making sure it's clear what the deal is that what's in writing in Colorado very well may be what's enforced, even if it's not quite what you intended. There are decisions in Colorado that hold it as negligent to sign without actually reading the document. So you're going to be stuck with what that document says, usually. Now, we talked a little bit about how people could have different ideas and how you could have a battle of the forms. You can also have other discussions between the parties negotiating what the deal is. Any good contract should have some portion of it that talks about what's called merger. What that means is any other discussions you've had, any other deals you've discussed, any other understanding you may have had leading up to the contract doesn't matter anymore. Instead, you have a final written document that gets rid of all prior discussions and debates about what the deal actually was. The written contract should be designed to be the final version with all prior negotiations being null, okay? This is called a merger because all the negotiations and draft all merge into the contract. So long as your contract is clear, unambiguous, well-written, and has the appropriate language to make it clear this is the final deal, you cannot bring in evidence of what people were discussing leading up to it for most purposes. This is called parole evidence, not to be confused with the parole which is used when you're in criminal court. That's spelled differently. This parole evidence means that you can't introduce extrinsic evidence to vary the terms of a written contract. In other words, it's not okay for your customer to come back and say, yes, I know I agreed to pay $20,000 for this work, but we actually talked about how I was going to get a discount and get it for $10,000. If the contract is unambiguous and has the price term in it, that is what Colorado courts are probably going to enforce. Now, there's an exception. The exception to this rule comes in the form of fraud. So if there is a representation of fact made to induce the contract being entered into, that can be something the court will look at. So if you get a deal with somebody claiming that you're licensed to do the work when you don't actually have that license, that can be a problem. If you represent to somebody that you've built all these different new extensions on 2-story houses for your customer to get them to hire you to do it, and then it turns out that this is the first one you've ever done, that kind of thing isn't just a negotiation of the contract. That can be a material representation of fact. And if it's not true, the contract can be tossed out for fraud. So, hopefully I've convinced you that your business should be using written contracts. Great choice. Now, the question is, what can we put in there? Well, remember, this document is you setting up your legal relationship that will define the duties and rights between you and your customer or other business, and it will dictate how fights down the road, if any, will be dealt with. So above all, and I can't say this enough, don't just get a form on the internet. You may have heard me say you shouldn't take legal advice from some stranger on the internet. You also shouldn't just take legal advice from random forms on the internet. Make sure the contract that you choose sets up rules about the way that you are going to do business, in the way you want to do business. For example, what kind of relationship do you want this contract to form? Studio client, employer-employee? Who owns the material that you produce? Is this a copyright situation? Are you doing work for hire? Are you just licensing software to somebody? Are you just generating, for example, raw footage or some kind of work product? What exactly is being promised? What are the deliverables? I see this in many contracts, and it always bothers me to no end. Take a look at your contract with your credit card company. Take a look at your contract with your cell phone company. See if you can, where in that document it says that they're supposed to be providing you with any particular kind of service. I'll tell you that in many I can't even find it. They're heavy on terms and conditions, not so great on discussing what the actual deal is. And this goes to other businesses too. I see many businesses which use a contract that essentially is nothing more than boilerplate terms and conditions, but never bothers to say, I'm going to do this work for this price by this date. If you're hiring somebody to do something a little unusual, like custom software, for example, being very clear about what the deliverables are, what the consideration is incredibly important and shouldn't be overlooked. When you're talking about, for example, videography, is this a one-time shoot? Is it going to happen in multiple locations? Is there going to be different settings done? Is there travel? What happens if there's a change of scope? Is there going to be a work order entered into? Is there going to be an increase in price? What is being paid? When will it be paid? Are you going to get a deposit, an upfront payment? What if the customer's not happy? How do you deal with customer complaints? How do you revise the document? How many modifications can you make and how? Is there going to be an indemnity? Is somebody going to, in the contract, be taking care of covering third-party problems that might be raised? These all have to be discussed and thought about when you're entering into a contract. And obviously, the more concerning the contract is, the larger the deal is, the more you have to think about these kind of things. But they're always relevant. So what happens if you do all this, you have a contract, and there's a breach? What happens if someone fails to do what they promised? That depends on the kind of relationship that you set up. Somebody who fails to act per a contract or acts in violation of the contract is in breach or default. There are certain elements to prove a claim of breach of contract. Number one, you must prove as the plaintiff that you substantially performed. So if you want to sue a customer for not paying you for construction work, you have to show that at least up until the date that you weren't able to keep doing it because of the customer's actions, you were substantially performing. You next have to show a material breach by the other party. Now, this is often fairly trivial if it's a contract that someone didn't pay on, for example. If They didn't write a check and they were supposed to, that's clear. But it can get a lot less clear when it talks about a contract for services being exchanged. Did the person do their job or not? Did they provide the deliverables? Did you define them well enough that you can actually articulate what they didn't do? You also, in addition to performance and breach, have to show damages. Again, lack of a check coming back for something you sold somebody, fairly easy to prove damages. But it can get complicated if it's not obvious how you were harmed. Even more so, if you were able to get goods from somewhere else for the same or a different price, you have to be careful about what your damages are. The law's expectation is that when you enter into a contract, you are expecting to pay or do whatever the contract said you were supposed to, and get whatever the other party said they were going to give or do for you. If you have to go and do more work or pay more money to someone else to get the same work, your damages are likely going to be the difference between the two prices. In other words, the law is going to try to put you back in the position that you were if everybody had performed as agreed. When you're enforcing your contract, another thing to think about is what kind of law and forum you want to be governing your dispute. Where is your lawsuit or arbitration going to happen? Do you want to drive to Mesa County or be sued in New Jersey? Do you want to be sued in a local court you're familiar with? Do you want arbitration? Arbitration is a way in which you can get through your case faster by hiring a private judge and potentially deal with it out of court. But this is not necessarily cheaper than going to court, and there's a lot of other wrinkles. But it's something you need to think about. It's a private, faster solution, not necessarily cheaper. Whose law is going to apply? If your contract is just between two people in Colorado and you don't specify, you're probably going to look at Colorado law. But many companies have presences in many states. If you are dealing with a Delaware company operating in Nebraska, signing a contract with a Colorado entity, whose law is going to control the dispute? Make sure it's in the contract. And then, of course, when you do sue a customer for not paying you or otherwise go after somebody in contract, and you are right and you win, you have to think about what your recovery is going to be. As we talked about, damages are easy to prove if it's someone who didn't pay. It can be more complicated in other formats, but even if it is some other kind of damage, the way that courts compensate people for contracts is typically going to be money. It's going to be money damages. And the goal of the money damages are going to be to put you back in the position that you would have been if the contract had been performed. I talked about this earlier, but imagine that you're a contractor doing work on a business or a piece of real estate, and you were going to have certain expenses to do the work, and you were going to get certain revenue from the customer. Your damages, if the customer doesn't let you perform, aren't just going to be the revenue for the most part. It's not just going to be the amount they should have paid you on the contract. It's going to be that minus what you would have had to do if you actually went through and did the project. It's your profits, in other words, the revenue minus the expenses. Similarly, if you take steps to mitigate your damage under the contract by hiring replacement labor or finding a different source of goods, your damages are more likely going to be the additional amount you had to pay to get the same result. But of course, there's other forms of damage too. Consequential damages deal with things that happen as an indirect result. So for example, if you have one customer who breaches a contract and that leads several other customers to breach their contracts, either because the work wasn't done, you had a bad reputation, something like that, you may be able, depending upon the terms of your contract, to go after them for consequential damages. Another important thing when you're thinking about remedies under a contract is collection costs. Under the American rule, which is the standard way we deal with attorney's fees in Colorado, whether you win or you lose, you pay your own attorney in this country. There are exceptions to that only if there's a statute or a contract that says so. So if you want to be able to recover the attorney's fees to sue on a contract you've entered into with somebody, you have to make sure it's in your contract. This is one of the biggest problems I've seen in contracts with people who wrote it without attorneys, or people who rely on simple purchase orders, or things like that. In a situation where you don't have an attorney's fee clause, you will quickly find out that sometimes a breach of contract, especially by a consumer or other smaller customer, is simply not worth the attorney's fees that it's worth to sue them for. It can be tens of thousands of dollars or much more, even for simple contract litigation. If you don't have the ability to recover those fees, you might not want to sue in the first place. One exception to the rule that you don't get your attorney's fees in court happens with third parties. So if somebody sells you the Brooklyn Bridge, and as a result you end up in a lawsuit with the person who actually owns the Brooklyn Bridge, if you were to sue the first person for a breach of contract or fraud or something like that, go after the guy who set you up, in that case you may be able to recover your attorney's fees as consequential damages. Otherwise, though, you're unlikely to recover them unless there's a statute or a contract that says so. Another thing people neglect in contracts a lot, especially the simple ones, are interest and penalty provisions. If your contract says that the vendor has to be paid $200 for each deliverable, but it doesn't have any interest that accrues if it's late, doesn't have any penalty if it's late, then the risk is that the economic interest on the part of the person making the payment is to wait as long as they possibly can so they can get the time value of money. Interest provisions help that by ensuring that if somebody doesn't pay on time, they will have to pay for the privilege of holding on to your money. In other words, you're not giving them a free loan. Now, in Colorado, if there's no interest specified in a contract, in most cases, we will apply an 8% maximum rate. But your contract can say otherwise, subject to usury laws. Another kind of remedy you can seek in a contract dispute is what's called specific performance. This isn't as common, but it exists. Now, specific performance is where the court orders somebody to act in compliance with a contract. It's going to be more common in the case of contracts where action or forbearance for action is important going forward, such as protection of trade secrets and that kind of thing. So we've talked about what goes into a contract, we've talked about how a contract is formed and what remedies exist. I'd like to close by talking a little bit about what I see as the major causes of breaches of contract. And I really think there's 4 main things that cause people to enter into my office and start complaining about a breach of contract. The first case is where somebody screwed up. You were hired to do something and it didn't get done right. Your subcontractor didn't do something the code requires. Some good that was supposed to be delivered wasn't available. The crop didn't get grown on time. In other words, somebody didn't do what they promised to do. And it wasn't through any necessarily bad intention, but it didn't get done. In a case of a screw up, there will be a claim for breach of contract. And hopefully your contract has terms that talk about it. The second thing that I've heard a lot of when people have breaches of contract, especially in business litigation, is a lack of understanding. Now, in theory, both parties are supposed to have mutual assent at the time they enter into a contract. In theory. In reality, sometimes people had a general understanding of what the deal was and may not have read the document as closely as they should have. They may not have had an attorney advising them. Where 2 people have a different understanding of what the deal is, such as 2 partners going into business together with different expectations, you can end up in massive contract fights. And depending upon the language of the contract, these can be easier or harder to resolve. Another reason I see people end up in breach of contract, and this one's unfortunate, is people simply acting in their self-interest. Sometimes you sign a contract and the price of what you're purchasing changes the next day. Sometimes you find someone who will do the job cheaper. This is not a very moral way to act, I don't think, but it certainly can happen where somebody decides that the risk of getting sued is worth the additional money they can save by acting in their self-interest. And the fourth thing I see that causes these kind of breach of contract disputes are outside problems. Pandemics shutting down your business, for example. Storms delaying the work out that has to be done outside, things of that nature. The reason that I put these 4 up here for you is because you should notice that as we go down the list, it gets harder and harder to control whether or not there's going to be a breach. As I said before, contracts exist primarily to give people a remedy, to use the state to enforce the deal. But far better to not have a breach in the first place. Now, when it comes to outside problems, by definition, there may be little you can do about that. You can add force majeure clauses. You can ask your attorney to try to think about what could possibly go wrong and how we're going to deal with it in advance. But by definition, third-party problems are hard to anticipate leading into a deal. Similarly, Unless you know the person you're contracting with fairly well, it's hard to know if their self-interest is going to guide them in a bad direction in the future. You can't really stop people from making good and bad choices. But for the first two, for lack of understanding what the deal is, or for someone screwing up and doing things incorrectly, those are well within a business owner's control. And it goes beyond this class a little bit, but there are things you can do to make sure your staff, your salespeople are well informed about so they can explain the contract to the customer. Because in a perfect world, if the customer understands the deal, understands why the terms and conditions are there, understands why they have the responsibilities they do, and why they're going to be subject to penalties if they breach, they're more likely to keep doing what they need to do. Similarly, if you have a tight control over your subcontractors and your employees, if you know that you can perform as agreed without problems, that also will make it much easier to minimize and prevent breaches of contract, which should be the goal. Thank you for attending this seminar in the Underhill Law Workshop series. You can reach out to us at underhilllaw.com or in the description below. If you have specific questions, obviously, hire an attorney to advise you on your rights and give you specific legal advice. Thank you.